Good morning. I hereby call to order this fifth meeting of the Pennsylvania Public Utility Commission for the year 2024. We welcome everyone joining us in the room today, as well as those watching on the live stream. Please stand for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
At today's meeting, which is open to the public, the Commission will act on various matters. There is no opportunity for the public to address the Commission at this public meeting. The public meeting motions, statements, and video will be available on the Commission's website later today. Before we start with today's agenda, I would like to recognize a special guest we have joining us today. Senator Pat Stefano is the chairman of the Senate Consumer Protection and Professional Licensure Committee, which is the PUC's oversight committee in the Senate. Senator Stefano, I know you join us always on the live stream, and it was great to have you in the room with us today. Accompanying Senator Stefano is Jen Smeltz. Jen is the committee's executive director. Thank you for joining us today. The first matter on this morning's agenda is the approval of the minutes of the meeting of February 22nd, 2024. I would like to recognize Commissioner Zerfas as the editor of the minutes. Commissioner Zerfas.
Thank you, Mr. Chairman. I have reviewed the minutes of the February 22nd, 2024 public meeting and move that they be approved as submitted, please.
You've heard the motion by Commissioner Zerfas. Is there a second?
Second.
Seconded by Vice Chair Barrow. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it. Minutes are approved by a vote of 5-0. Madam Secretary, we're ready for your presentation.
Good morning, Mr. Chairman. Good morning, Commissioners. Your various bureaus and offices have prepared the following agenda items for your consideration. Therefore, let us begin on page 1 with the recommendation of Director Moore and the Bureau of Consumer Services that the Commission adopt the proposed order regarding the proposed Universal Service and Energy Conservation Plan filed by Columbia Gas of Pennsylvania.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Yanora. Any discussion? Hearing none, all those in favor, please say aye. Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Turning to page 2, in matters presented by Director Hafner and the Office of Special Assistance, it is recommended that the Commission adopt the proposed opinion and order in the formal complaint of Judith Hendon versus the Metropolitan Edison Company.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Zerfas, seconded by Vice Chair Barrow. Any discussion?
Mr. Chairman, I have a motion.
Vice Chair Barrow.
Thank you. Please enter this motion into the record as if read in its entirety. Before us for consideration is the petition filed by Judith Hendon seeking reconsideration of our January 26, 2024 order. I wish to speak on a few of the stated grounds for reconsideration. First, the complainant's request for reconsideration based on the case Environmental Health Trust should be rejected. This issue was raised in the 2022 PA Supreme Court decision in POVAC, which concluded that Environmental Health Trust provides no guidance because it did not reach the merits of the FCC standards and did not constitute a game changer as alleged by the appellants in that case. So I believe there's no reason to reconsider or go beyond the POVAC's court's analysis. Environmental Health Trust does not support a claim that RF emissions at or below the 1996 FCC limits cause adverse human health effects, and in no way overcomes the record facts that Hendon here failed to adduce sufficient evidence to meet the preponderance of the evidence standard. Second, with respect to the complainant's new electrosmog arguments, these arguments could have been raised at the outset of the case. Because they were not, they are waived and offer no persuasive value for changing the order. Therefore, I move that the petition for reconsideration is denied, consistent with this motion, and that the Office of Special Assistant shall prepare an opinion and order consistent with this motion. Thank you.
Thank you, Vice Chair Barrow. We've heard the motion by Vice Chair Barrow. Is there a second?
Second.
Seconded by Commissioner Coleman. Any discussion? I do have a conflict statement. Before joining my staff as legal counsel, Joel Cheskis was employed in the Commission's Office of Administrative Law Judge and worked on this case. Please note he has not advised me in this matter. Any further discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. Motion passes by a vote of 5-0. On the matter as amended by the motion, is there any objection to taking the previous roll call? Hearing none, matter passes as amended by the motion by a vote of 5-0. Madam Secretary.
Turning to page 3, it is recommended that the Commission adopt in an omnibus motion both items on page 3, beginning with the formal complaint of Jeff Day versus the Duquesne Light Company, and ending the omnibus with the formal complaint of Michael Marcosi versus the Metropolitan Edison Company.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Yanora, seconded by Commissioner Coleman. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. Ayes have it by a vote of 5-0. Madam Secretary.
Turning to page 4, it is recommended that the Commission adopt the proposed opinion and order in the formal complaint of John Kerr Musgrave versus the Pittsburgh Water and Sewer Authority.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Zerfus. Any discussion?
Chairman, I have a motion.
Vice Chair Barrow.
Thank you. Please add this motion to the record as though I read it in its entirety. The matter before us involves allegations by Mr. Musgrave against Pittsburgh Water and Sewer Authority. He alleges that they violated the law by not repairing line breaks, which occurred between January 2018 through November 2020. As background, we have Act 65 of 2017, which amended Section 1301 of the Code to include municipal corporations under the PUC's jurisdiction. Act 65 became effective when signed by Governor Tom Wolf on December 21st, 2017. Pursuant to Act 65, Chapter 32 of the Code was applicable as of April 1st, 2018. With minor exceptions. Therefore, PWSA became subject to the rules in Chapter 32 on April 1st, 2018. This matter involves allegations related to water line breaks on a shared service line located on a portion of Bunker Hill Street that occurred on or about January 22nd, 2018 and July 27, 2020. A portion of Bunker Hill Street was serviced by a private single-share service line, also called a party line, which provided water service to 6 properties, including Mr. Musgrave's. The party line connected to the PWSA water main on the public portion of Bunker Hill Street. Prior to 2018, the party line experienced a break in January 2015, in March 2017, and PWSA repaired both of those breaks, even though the party line was the responsibility of Mr. Musgrave and his neighbors. On January 22nd, 2018, the party line experienced another break, and as usual, Mr. Musgrave contacted the company to repair the leak. The company refused to complete the January 2018 repair, explaining that the party line was a private service line and that PWSA was not responsible for the repair and maintenance of the line. This is, of course, out of character with what they had been doing, but it was not incorrect. Mr. Musgrave and his neighbors hired a private plumber to complete the January 2018 repair. The party line experienced another break on July 27, 2020, which was later replaced by PWSA in November of 2020 through its lead service line replacement program. The July 19, 2023 initial decision held that PWSA aired when it moved the curb box, lengthened the service line, and installed the service line below the property of 5 neighbors, and when it refused to continue its longtime practice to maintain and repair water lines serving these addresses without notice in July of 2020. And Musgrave filed exceptions. I disagree with the ALJ's findings on this matter. First, through various interim orders, the matter was limited to 2 claims: that PWSA had maintenance and/or repair responsibilities over the service line running along the private portion of the private street prior to November 11, 2020, and failed to perform those responsibilities, resulting in waterline breaks in January 2018, February 2020, and July 2020. And also that PWSA failed to maintain proper levels of chlorine in its water provided to the service address between May 2018 and October 2020. The claims and allegations relating to the curb box and lengthening of the new service line were not within the scope of this matter. Accordingly, exception number 1 filed by PWSA should be granted, and the ALJ's recommendation should be reversed. Second, as I explained, PWSA became subject to the Commission's jurisdiction on April 1st, 2018. Thus, the allegations relating to unreasonable and inadequate maintenance and repair services during the January 2018 party line break predate this Commission's jurisdiction and authority over PWSA. With regard to the July 2020 break, the record demonstrates that PWSA was not required or allowed by law or its tariff to complete the repairs on that private party line, and that PWSA provided notice to Mr. Musgrave and his neighbors that it would not complete repairs on the private party line during the January 2018 break. Thus, notice was provided. Furthermore, PWSA's practice of repairing private service lines pre-2018 and prior to becoming subject to the Commission's jurisdiction does not create a legal obligation for it to continue this practice. In light of the January 2018 allegations predating the Commission's jurisdiction, and because PWSA provided notice to Mr. Musgrave and his neighbors that it would not repair the private party line, I mean, I'm not crazy about the way they did it, but it was done due to the Commission's regulations and its tariff, and because PWSA's tariff and the Commission's regulations after April 1st, 2018 do not allow PWSA to complete repairs on private service line, there's no basis to find a violation in this matter. Therefore, I move that the exceptions filed by PWSA to the initial decision issued on July 19, 2023 should be granted. 2, that the exceptions filed by Mr. Musgrave filed by Mr. Musgrave are granted, that the initial decision of ALJ Dunderdale issued on July 19, 2023 is reversed, consistent with this motion, that the formal complaint of John Musgrave is dismissed, consistent with this motion, and that the Office of Special Assistants prepare an opinion and order consistent with this motion. That's all.
Thank you, Vice Chair. We've heard the motion from Vice Chair Barrow. Is there a second?
Second.
Seconded by Commissioner Coleman. Any discussion? I do have a joint statement along with Commissioner Zerfus. We would like our statement to be entered into the record as though we have read it in its entirety. The case involves a complaint brought by a customer against PWSA and alleges the PWSA provided unreasonable service. Mr. Musgrave and his mother reside on a private private portion of a street in the Highland Park neighborhood of Pittsburgh. Prior to November 2020, they received water service on a private shared water service line. The line was constructed in 1929 and historically provided water service to 6 residences, including the Musgrave residence. The record reflects that prior to the time the PWSA became subject to the Commission's jurisdiction, PWSA repeatedly repaired breaks that occurred on this line and had done so for approximately 30 years. However, when a water line break occurred on this service line in January 2018, PWSA did not repair the line, and the property owners hired a private plumber to repair the line for the first time. PWSA contends that it did not repair the line because it was transitioning to being subject to the Commission's jurisdiction and no longer have flexibility to assist with repairs to private water lines. Another water line break occurred on the shared service line in July 2020, which was unable to be repaired. The line was ultimately replaced by PWSA in November 2020 through its lead line replacement program. In the meantime, Mr. Musgrave, his mother, and 2 other households, with PWSA's awareness, received water service from hoses connected to a fire hydrant. The record also reflects that PWSA was not obligated to repair private water lines, and that private water lines were always the customer's responsibility, even prior to PWSA being subject to Commission jurisdiction. PWSA acknowledges, however, that it repaired breaks in private water service lines pre-Commission jurisdiction, even though it was under no legal obligation to do so. Based on our review of the totality of the evidence, we find that Mr. Musgrave met his burden in proving by a preponderance of the evidence that PWSA provided unreasonable service in violation of Section 1501 of the Public Utility Code. We find that PWSA failed to provide adequate communication of its change in policy to not assume maintenance responsibilities over private water lines. Prior to 2018, PWSA essentially treated the Musgraves line as its own by repeatedly repairing the line. When the water line break occurred in 2018, PWSA notified Mr. Musgrave for the first time that it would not repair the line. There was no indication from PWSA that this change in policy would apply going forward. In fact, PWSA's witness testified that PWSA was not obligated to provide any notice and saw no reason to send out notifications since it was a private line. Likewise, Mr. Musgrave testified that PWSA provided no notification, either verbal or written, about this change in policy. We do not find that PWSA successfully rebutted Mr. Musgrave's testimony concerning inadequate notification. Under the facts of this matter, it was reasonable for Mr. Musgrave to accept PWSA to continue repairing the private line consistent with PWSA's long history of repairing that line. A common sense business practice would have been for PWSA to notify Mr. Musgrave and similarly situated customers of its change in policy of no longer repairing the shared service line. In fact, the line break of January 2018 was the perfect opportunity for PWSA to repair that line one more time, as they were not under Commission jurisdiction until April of that year, and let them know that this was the last time the line would be repaired, as they were coming under Commission jurisdiction. We find a lack of advance notice from PWSA to Mr. Musgrave regarding his changed position constituted unreasonable service, especially when considering the vintage of the water line. PWSA's witness testified that it is common for a line close to 100 years old to start to have leaks. It is nearing its end of useful life. PWSA was aware of Mr. Musgrave's situation and other neighbors on the shared service line and had ample time between April 1st, 2018, when PWSA became subject to the Commission's jurisdiction, and July 2020, when the line failed, to provide adequate notice to Mr. Musgrave so as to allow him to prepare for a very costly repair. While we find that PWSA violated Section 1501 by providing unreasonable service, based on our consideration of the Rossi standards, we would not impose a civil penalty here. Significantly, PWSA's actions were prudent in ceasing to continue using ratepayer funds to pay for the repairs of private water lines after the time that PWSA became subject to Commission jurisdiction. While we do not find that a civil penalty for PWSA's violation is appropriate in this instance, the Commission is empowered to impose civil penalties on PWSA under the Public Utility Code. All civil penalties are required to be deposited in the Commonwealth's general fund. PWSA is unique in that ratepayers and/or taxpayers ultimately pay the cost of civil penalties, not investors. It would be prudent for the Commission to be granted the authority to direct a civil penalty imposed on PWSA or any other municipally owned utility system under our jurisdiction towards a universal service program, such as a hardship fund, so that ratepayer funding of a penalty can be allocated back to customers of that utility and possibly reduce potentially uncollectible expenses. Therefore, we support the initial decision as modified, as we find the PWSA violated Section 1501 by providing unreasonable service. Thank you. Any other comments? Vice Chair?
Yes, thanks. I do agree with the last part of your statement about the way that civil penalties for municipal utilities are treated.
Thank you. We have a legislator in the audience, so there you go. On the motion, all those in favor, please say aye.
Aye.
Those opposed, no?
No.
No. The ayes have it by a vote of 3-2, noting the dissents of myself and Commissioner Zerfus. On the matter as amended by the motion, is there any objection to taking the previous roll call? Hearing none, matter passes as amended by the motion by a vote of 3-2, noting the dissents of Commissioner Zerfus and myself. Madam Secretary.
Continuing at the bottom of page 4, it is recommended that the Commission adopt the proposed opinion and order in the application filed by Columbia Gas of Pennsylvania.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Zerfus, seconded by Vice Chair Barrow. Any discussion? I do have a statement in this matter. I would like my statement entered into the record. Any further discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Turning to page 5, it is recommended that the Commission adopt the proposed opinion and order regarding the affiliated interest agreement filed by the Buck Hill Water Company and the Buck Hill Falls Company.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Coleman, seconded by Commissioner Yanora. Any discussion?
I have a brief statement.
Vice Chair Barrow.
Thank you. My only concern with this case is what I see as the continued misstatement of the PUC's reconsideration standard under DUIC. I've elaborated on that in the past. Same issue. Thank you.
Thank you. Any further discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Continuing at the bottom of page 5, it is recommended that the Commission adopt in an omnibus motion, beginning with the formal complaint of Peter Mordizeko versus the Philadelphia Gas Works, and including and ending the omnibus motion at the top of page 6 with the application filed by FND Partners.
Is there a motion to consider the staff recommendations?
So moved.
Is there a second?
Second.
Motion made by Commissioner Yanora, seconded by Vice Chair Barrow. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Turning to page 7, in matters presented by Director Diskin and the Bureau of Technical Utility Services, it is recommended that the Commission adopt in an omnibus motion both items on page 6, beginning with the application filed by Renaissance Power and Gas, and including both items on page 8, ending the omnibus with the suspension of the rate increase proposal filed by Columbia Gas of Pennsylvania.
Is there a motion to consider the staff recommendations?
So moved.
Is there a second?
Second.
Motion made by Commissioner Zerfus, seconded by Commissioner Coleman. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Turning to page 9, in matters presented by Chief Counsel Screven and the Law Bureau, it is recommended that the Commission adopt the proposed policy statement setting forth guidelines regarding the utilization of storage resources as electric distribution assets.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Zerfus. Any discussion?
Chairman?
Vice Chair Barrow.
I have a statement. Madam Secretary, please enter this statement into the record as if I read it in its entirety. Since the beginning of electric competition in Pennsylvania, one of the goals of the General Assembly has been that the General Assembly has tasked this commission with carrying out is to use the power of competition to minimize cost and risk to ratepayers, and instead allow generators to connect to the grid and compete to provide service to load. The expansion of storage options presents difficult questions for the divested structure of our modern grid in Pennsylvania. Storage can clearly satisfy a distribution function. A storage facility can increase resilience and maintain temporary service to an area if a radial wire is knocked down. A storage facility can reduce needed peak transfer capability of a line, increasing load factor, and reducing facility costs to ratepayers. Storage facilities also have aspects that look more like generation. They can store energy when it's cheap. They can respond to higher locational prices to inject energy into the grid, to resolve congestion, and serve load without building transmission facilities. And those transmission facilities are getting more and more expensive. PJM allows storage to participate in wholesale markets like standard generation to the greatest degree possible. The storage policy statement we're offering today attempts to strike the balance between the features of storage that serve as a potential distribution asset and the features that look more like generation. I believe that storage can and should be considered a distribution asset under the Electric Choice Act. In order for storage to be used by EDCs in this manner, the facility must serve a distribution purpose, not a purpose served by competitive generation. The policy statement encourages the consideration of storage as a distribution asset. Such an asset is prudent only when the competitive electricity markets are not reasonably or cost-effectively able to serve the function of the electricity storage asset. This is consistent with our legislature's conclusion that competitive market forces are more effective than economic regulation in controlling the cost of generating electricity. A competitive storage facility that is not rate-based is preferable to a rate-based distribution facility if it can serve the same purpose. Some of the criticisms in the comments are particularly valid given the power of smaller distributed energy resources. While historically generation has operated at a very large scale, it's becoming more apparent that customers may have options to locate storage resources directly at their electric load. These distributed competitive markets have the opportunity to serve the same resilience or congestion mitigation functions as a distributor-owned asset, and the specific function should be considered in whether a distributor-owned storage facility is performing an acceptable and cost-effective role. I'm kind of belaboring this point because the last thing I want to see is EDC ratepayers being burdened by costs that I think the competitive markets can bear more effectively, more efficiently. But please don't let the takeaway be that I'm against storage as a distribution asset. I am very much for it. We just have to be really careful in how we consider it. Thank you.
Thank you, Vice Chair Barrow. Any further discussion? I do have some brief comments on this. Today, the Commission deliberates final action to codify an energy storage asset policy statement. This proceeding commenced on November 19th, 2020, when Chairman Gladys Brown-Dutrail motioned to research policies related to the utilization of electric storage within EDC resource planning. The Commission must strive to avail EDCs with all the necessary tools to provide safe and reliable service. The record here exhibits the benefits storage can provide as non-wires alternatives to distribution infrastructure. In turn, this policy statement acknowledges the value that storage assets can bring to electric utility service and encourages EDCs to consider their utilization when reasonable and prudent. I believe this policy will increase regulatory clarity for EDCs. This will assist the EDCs in managing the ever-dynamic utility landscape comprised of load growth, distributed resources, cyber threats, extreme weather, and other evolving variables. Therefore, I am pleased to support this action and look forward to seeing EDC future applications of electric storage as non-wires alternatives. Any further discussion? Hearing none, all those in favor, please say aye. Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Continuing at the bottom of page 9, it is recommended that the Commission adopt the proposed order in the petition for declaratory order filed by the Williams Companies.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Coleman. Any discussion? Hearing none, all those in favor, please say aye. Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Turning to page 10, and matters presented by Chief ALJ Rainey and the Office of Administrative Law Judge, it is recommended that the Commission adopt the initial decision of ALJ Long in the formal complaint of Monica Smith and Michael Williams versus the Metropolitan Edison Company.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Unora, seconded by Vice Chair Barrow. Any discussion? Hearing none, all those in favor, please say aye. Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Continuing on page 10, it is recommended that the Commission adopt the initial decision of ALJ Long in the formal complaint of G.E. Stallman versus the West Penn Power Company.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Zerfas, seconded by Vice Chair Barrow. Any discussion? I do have a motion in this matter, and I would ask the Vice Chair to chair the meeting.
Chairman, I recognize you for purposes of your motion.
Thank you. I ask that my motion be entered into the record as though I read it in its entirety. On January 10th, 2024, the Office of Administrative Law Judge issued an initial decision in this matter involving the complaint filed by Mr. Stallman against West Penn Power Company dated November 27th, 2020. On the formal complaint, Mr. Stallman checked the boxes indicating that the reasons for the complaint were: 1, the utility is threatening to shut off his service or has already shut off his service; 2, he's having a reliability, safety, or quality problem with his utility service; and 3, other. As further explanation for other, Mr. Stallman added that smart meters seriously threaten entire populations. Mr. Stallman also attached to his formal complaint 4 single-spaced typed pages elaborating on why he believes smart meters seriously threaten entire populations. Mr. Stallman's complaint was stayed via commission order pending resolution of similar smart meter cases that were on appeal. The stay of those cases were lifted by commission order entered November 14th, 2023. As such, on December 4th, 2023, West Penn filed an answer in new matter in response to Mr. Stallman's complaint, admitting or denying the averments made therein. In its matter, West Penn stated that Mr. Stallman's complaint is moot because the Supreme Court's decision in the related appeals held that customers are not allowed to opt out of smart meter installation. West Penn filed a preliminary objection on the same date, arguing that the complaint is legally insufficient because the relief requested by Mr. Stallman cannot be granted by the Commission based on the Supreme Court's decision. In the initial decision, the ALJ found that the only issue raised in the formal complaint is the general opinion that smart meters are harmful and that the Commission should abolish smart meters. The ALJ added that the Pennsylvania Supreme Court has definitely held that state law requires electric distribution companies to install smart meters, and therefore there is no relief that the Commission can grant as a matter of law. The ALJ then dismissed the complaint on a preliminary basis. Upon review of the pleadings and applicable law, the initial decision should be reversed, and this matter should be remanded to the Office of Administrative Law Judge for further proceedings. According to the initial decision, the Supreme Court held that customers have no right to refuse smart meter installation. The initial decision finds that Mr. Stallman does not identify any specific health condition from which he suffers other than a generalized belief that smart meters are harmful, and concludes that a hearing is not necessary or in the public interest. I disagree. When viewing Mr. Stallman's complaint in the light of most favorable to him and accepting all well-pleaded material facts in the complaint, as well as every reasonable inference that from those facts, it is clear that Mr. Stallman would not be entitled to relief under any circumstance as a matter of law. This is true because, separate from finding that there is no opt-out provision for smart meter installation in the law, the Supreme Court confirmed that challenges to smart meter installation may arise under 1501 of the Public Utility Code, noting that customers with concerns about smart meters may also seek an alternative resolution from the electric company. This includes health concerns stated by Mr. Stallman in the attachment to his complaint. While I recognize the averments in the attachment, Mr. Stallman provided are of general nature regarding health issues. These statements must be accepted as true when addressing West Penn's preliminary objection. It is reasonable to infer that these statements warrant denying West Penn's preliminary objection and giving Mr. Stallman an opportunity to proceed with his complaint. For example, the attachment lists various reasons why smart meters threaten the health and life of humans, including cancer and heart disease. I believe that Mr. Stallman's complaint is sufficiently pled in a way that he should have been given an opportunity to proceed with his complaint and not have his complaint dismissed on the basis of West Penn's preliminary objection. This is particularly true given that Mr. Stallman is appearing as a pro se complainant. Similarly, I do not agree that the case should be dismissed on the grounds that the Commission does not have the authority to grant the relief requested by the complainant. It may turn out, following further proceedings, there is some other relief that the Commission can order that is in the public interest. It is consistent with the Supreme Court's decision that an alternative resolution can be made for Mr. Stallman. We will not know this, however, if the complaint is dismissed at the preliminary stage. Therefore, it is not appropriate that this matter be dismissed on the basis of West Penn's preliminary objection. As a result, the initial decision must be reversed and remanded back to the Office of Administrative Law Judge for further proceedings as deemed necessary. This may include determining whether a reasonable alternative resolution could be made to address Mr. Stallman's concerns. Therefore, I move that 1, the initial decision of Administrative Law Judge Mary D. Long be in Stallman v. West Penn Power Company at docket number C 2020-302-3227 be reversed, and the proceeding be remanded back to the Office of Administrative Law Judge for further proceedings as deemed necessary. And 2, that the Office of the Special Assistants prepare an opinion and order consistent with this motion. Thank you.
Thank you, Chairman. Is there a second to the motion?
Second.
Seconded by Commissioner Yanora. Are there any objections? Hearing none. All those in favor of the motion say aye.
Aye.
On final adoption, is there any objection to taking the previous roll call? No. Hearing none, the recommendation is adopted as amended by the vote of 5-0. Returning to you.
Thank you, Vice Chair Barrow. Madam Secretary.
Turning to page 11, it is recommended that the Commission adopt the initial decision of ALJ Haas in the formal complaint of William J. Harding versus the West Penn Power Company.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Zerf is seconded by Vice Chair Barrow. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Continuing on page 11, it is recommended that the Commission adopt the initial decision of ALJ Dunderdale in the formal complaint of Richard Valentino versus Verizon Pennsylvania, LLC.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Zerf is seconded by Vice Chair Barrow. Any discussion?
Chairman, I have a motion.
Vice Chair Barrow.
Thank you. Please enter this motion in the record as though I have read it in its entirety. On June 1st, 2023, Mr. Valentino filed a formal complaint against Verizon PA, averring several years of service issues with Verizon and noting many instances where communication dropped due to static, losing communication during telehealth calls with physicians, and ongoing internet issues. The January 17th, 2024 initial decision sustained the formal complaint, finding Mr. Valentino successfully proved that Verizon failed to provide reasonable, adequate, and reliable telephone service. The ALJ directed Verizon to return to the service address and attempt to resolve the telephone issues within 30 days, to create a report of the actions taken, and to provide a copy of the report to the Commission's Bureau of Technical Utility Services within 60 days. On March 18, 2024, Verizon filed its report outlining actions taken following the hearing and the initial decision. Notably, while Verizon described as actions related to Mr. Valentino's internet and DSL complaints, the report does not appear to address Mr. Valentino's telephone complaints. If Verizon has already addressed the telephone issues but inadvertently omitted its actions in that March 18th, 2024 report, I ask that Verizon file an amended report within 30 days. If that's not the case, Verizon should return to the service address to attempt to resolve the telephone service issues. A report of any subsequent remedial action carried out by the company to address Mr. Valentino's telephone issues should be filed with the Commission within 60 days. Therefore, I move that the initial decision of ALJ Katrina Dunderdale, issued on January 17, 2024, is modified consistent with this motion. 2, that the formal complaint of Richard Valentino is sustained consistent with this motion. And 3, that the Office of Special Assistants prepare an opinion in order consistent with this motion. Thank you.
Thank you, Vice Chair Barrow. We've heard the motion by the Vice Chair. Is there a second?
Second.
Seconded by Commissioner Yanora. Any discussion?
Chairman, I do have a statement on this case.
Commissioner Coleman.
Thank you. I have a written statement that's basically just setting forth our jurisdiction over this customer's internet service, and I will spare all of you the reading of that statement today and just ask that it's entered into the record in its entirety. Thank you.
Thank you. Any further discussion? Hearing none, all those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it by a vote of 5-0. On the matter as amended by the motion, is there any objection to taking previous roll call? Hearing none, the matter passes as amended by the motion by a vote of 5-0. Madam Secretary.
Turning to page 12, it is recommended that the Commission adopt the initial decision of ALJ Brady in the formal complaint of Patricia Rearick versus the PECO Energy Company.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second?
Motion made by Commissioner Zerfus, seconded by Commissioner Coleman. Any discussion?
Chairman, I do have a statement.
Vice Chair Barrow.
Madam Secretary, I'm going to ask you to enter my statement into the record as though I read it in its entirety. I will attempt not to. I agree with the ALJ's dismissal of the formal complaint, but I think it should have been dismissed without prejudice. The formal complaint seeking a payment arrangement was filed on June 12, 2023. PECO's answer avers that the service address was awarded a PECO payment arrangement on June 16, 2023, 4 days later, and that the balance was zero and the account was not under threat of termination at that time. Accordingly, it's understandable, or it's at least within reason to understand why Ms. Rearick did not attend the hearing, and it's unclear why PECO didn't file a certificate of satisfaction or provide other notice that the matter had been satisfied. Also, I would caution PICO to follow the code and our regs when calculating its deposits. The calculation did not add up to me. Thank you.
Thank you, Vice Chair Barrow. Any further discussion? Hearing none, all those in favor, please say aye.
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 Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Continuing on page 12, it is recommended that the Commission adopt the recommended decision of ALJ Collins in the joint petition and full settlement between CSX Transportation and PennDOT.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Coleman, seconded by Commissioner Yenora. Any discussion?
Chairman, I have a statement.
Vice Chair Barrow.
Prior to joining my staff, Kayla Ross worked for INE and was assigned to this case. She has not advised me on the matter.
Any further discussion? Hearing none, all those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Mr. Chairman, that concludes the regular agenda. Turning now to the carry-in agenda. On page 1 of the carry-in, it is recommended by the Bureau of Technical Utility Services that the Commission adopt the proposed order suspending the rate increase proposal filed by the Duquesne Light Company.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second? Second. Motion made by Vice Chair Barrow, seconded by Commissioner Yenora. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Turning to page 2 of the carry-in, it is recommended by the Law Bureau that the Commission adopt the proposed order in the petition for reconsideration filed by the First Energy Companies regarding the Commission's order on the Pennsylvania Electric Company's Universal Service and Energy Conservation Plan.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Zerfus, seconded by Commissioner Coleman. Any discussion? Hearing none, all those in favor, please say aye.
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 Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Turning to page 3 of the carry-in, Mr. Chairman, there is the joint motion of Vice Chair Barrow and Commissioner Zerfus regarding the rulemaking for diversity reporting of major jurisdictional utilities.
Recognize Vice Chair Barrow for her motion.
Thank you. Madam Secretary, please enter this joint motion into the record as though I read it in its entirety. And this is the joint motion of myself and Commissioner Zerfus. On April 14, 2022, the Commission voted to adopt regulations requiring regular reporting on diversity programs and efforts by major jurisdictional utilities providing electric, natural gas, water, and wastewater services. The diversity reporting regs at Chapter 51 were enacted on September 17, 2022. The regulation built upon the Commission's policy statement from 1995, which encouraged diversity reporting. Our 2020 update to the policy statement expanded diversity reporting guidelines to include minorities, women, persons with disabilities, LGBTQ, and veterans. And the regulations standardized the definitions and format required for the applicable major jurisdictional utilities, those with net plant and service of 10 million or more, to annually file and what they would have to file. The reason for doing this was that keeping apprised of major jurisdictional utilities diversity initiatives provides the Commission with valuable insight into how utilities are able to attract the labor force needed to provide safe, reasonable, efficient, and reliable service. As stated by former Chairman Dutrell, corporate diversity is not a social justice issue. When we're looking at it, it's a financial issue. And I will spare you all of the background, but we looked at studies that documented the relationship between diversity and improved financial performance. So this has always been about transparency. And so what this motion attempts to do, what we're attempting to do, is to really just take that last step, close the loop in this initiative that was begun a couple years ago. So we are directing TUS in coordination with the Law Bureau to compile the information filed at this docket and issue reports regarding our utilities filings that will be published annually on the Commission's website. The report should contain statistics, including whether any trends have been identified in the information the utilities have provided, and shall retain the confidential nature of the information reported so that no specific company is identified. We emphasize that any sensitive information files, such as LGBTQ specifics, persons with disabilities data, and company policies related to procurement and training, will not be disclosed. Also, we note that because Pennsylvania is a diverse state, including the census statistics of a given utility service territory, we do not expect, nor can we legally direct our utilities to achieve a certain diversity ratio or quota, nor will the lack of diversity be cause for any further commission action. This has always been about transparency. Therefore, we move that the Bureau of Technical Utility Services, in coordination with the Law Bureau, shall, by May 31st, 2024, issue an annual report regarding the diversity efforts of the utilities subject to to sections 51.11 through 51.13 of the regs for the annual reports filed in 2023 and 2024 respectively. 2, that the Bureau of Technical Utility Services, in coordination with the Law Bureau, shall by May 31st of each year issue the same report. 3, if no responsive comments to this motion are filed by April 19th, 2024, this matter shall be adopted without further commission action. And 4, that the Office of Special Assistant shall prepare an opinion and order consistent with this motion. Thank you.
Thank you, Vice Chair Barrow. We've heard the joint motion of Vice Chair Barrow and Commissioner Zerfus. Is there a second?
Second.
Seconded by Commissioner Yenora. Any discussion?
Mr. Chairman.
Commissioner Zerfus.
Mr. Chairman, Madam Secretary, I have a statement. I am not going to read it, but I would like to submit it for the record, so please add it as if I read it in its entirety. Thank you.
Thank you, Commissioner Zerfus. Any further discussion?
Chairman, I do have a statement as well.
Commissioner Coleman.
Thank you, and I would ask that my statement be entered to the record as though I read it in its entirety. I'm going to be voting no on this joint C motion this morning, and I just want to summarize just a couple of quick points here. Back in February of 2020, I did support the former chairman, Gladys Dutrell Brown, in undertaking review and updating the Commission's diversity policy statement. And after this review was completed and the policy statement was revised, I also supported the Commission's rulemaking that created mandatory reporting for our jurisdictional utilities, and that this was a report that was for internal consumption, meaning this was for this Commission's use and exclusively for that, and that's why I was supportive. What we're doing today is broadcasting that information out to the general public and posting it on our website. So I want to emphasize this morning that I do continue to support and encourage our utilities and their workforce and supplier diversity efforts. However, I don't agree with the decision to publish the utility demographics for the reasons that I'll set forth in my statement this morning. So thank you for that, and that's all I have.
Thank you, Commissioner Coleman. Any further discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no.
No.
The ayes have it by a vote of 4-1, noting the dissent of Commissioner Coleman. Madam Secretary.
Mr. Chairman, that concludes the carry-in agenda. Turning now to the supplemental carry-in. On the supplemental carry-in agenda, there is your joint motion, Mr. Chairman, with Commissioner Yenora regarding application and certification procedures.
Thank you. I will recognize Commissioner Yenora to read our motion. Commissioner Yenora.
Thank you, Mr. Chairman. I'll introduce our joint motion. We ask that our joint motion be entered into the record as if we read it in its entirety. Recently, our agency participated in the Shapiro administration Permit Connect PA workshop. The workshop focused on building efficiencies in Commonwealth permitting, licensing, applications, and certification procedures. Its goals is to reduce the cost, time, and uncertainty of obtaining review from regulatory agencies charged with oversight of business activity in the Commonwealth. Achieving efficiencies within the regulatory review process is crucial to a long-term investment in our Commonwealth. To begin this process at the PUC, each bureau will inventory each type of its assigned applications proceedings, not subject to fixed regulatory or statutory deadlines. The Bureau inventory will detail the methods by which the Commission receives the filings, the authority under which approval or denial is issued, whether the publication of the application is required, whether the application is subject to protest or protest period, a description of the Bureau tasks. Based on the inventory, the Office of Executive Director will examine the average time each Bureau takes to review the inventory application and the total average processing time from the filing to the final Commission's decision. The Office of Executive Director will evaluate process improvements with an initial goal reducing total average processing time by at least 15%. This goal will work to achieve a responsive, effective, and empowerment of the stakeholders, innovators, local communities, and state agencies to ignite economic growth and promote prosperity throughout the Commonwealth. Therefore, we move that 1, effective bureaus will develop an inventory in compliance with the directives of joint motions within 60 days of this adoption. 2, the Office of Executive Director will produce the report of the Commission considering setting the process and movement with the goals of reducing total average processing time by at least 15% within 6 months of adoption of this joint motion. Thank you.
Thank you, Commissioner Yenora. You've heard the joint motion by myself and Commissioner Yenora. Is there a second?
Second.
Seconded by Commissioner Zerfus. Any discussion?
Chairman, I have a statement.
Vice Chair Barrow.
Thank you. I applaud Governor Shapiro's Permit Connect initiative. It's my understanding that it was carried out following extensive research and input from the agencies under the governor's jurisdiction. And I cannot argue with the fact that every organization, including the PUC, can become more efficient and serve its customer base better. What I can argue with is setting out any kind of goals or targets when we as an agency have not done our research, we have not done our homework. The Commission just signed a contract with an outside vendor to take a look at whether our organization chart is properly suited to the work that we do today, whether we are doing our work efficiently. The ink isn't even dry on that contract, and now we're setting out goals for processing times. We're putting the cart before the horse, and I'm not comfortable doing that. I would like to let the vendor that we just hired go through our org chart, look at what we're doing, point out where they think there can be improvements, get input from the bureau directors, from the commissioners, and after that, we lay out where the improvements can be made. So I don't have a problem with pointing out that we can make improvements. It's the manner that we're going about doing it. To set an arbitrary 15% goal or any number is, we're just doing it too soon. Also, what's not logical to me is targeting applications that don't have statutory deadlines. The work that our professional staff does is at times pure drudgery. And that doesn't mean that that work is not important. We're talking about transmission line sightings, we're talking about gas pipeline sightings, we're talking about applications to transport passengers safely to and from wherever they're going. And I think that the time that is put into processing those applications is just as important as the applications that have a statutory deadline. And I would like us to really be thoughtful before we put any kind of goals out there. I like to do my research before I vote on anything, and I don't have the data to vote on this. So it is not it's not something I do lightly, but I just don't have the data, so I can't support the motion.
Thank you. Any further discussion? I would like to address some of the concerns the Vice Chair raised. I think what the intent of the motion is to do is to compile that data, and that's what the purpose of the inventory is. I think it's our plan then is to utilize the strategic plan to tell us how we find those efficiencies, but we have to tell the folks doing the strategic plan what we do, what permits we offer, how we process applications. So we think it's the perfect time to start this and then allow the strategic plan to show us where those efficiencies can be. The 15%, I understand your concern about that. We took that directly from the governor's order. We have been working with the front office as well as folks like Dr. Regley and Ben Kirscher in asking what we can look at, because they're the ones that headed up the efforts for the agency. But I also want to point out what happens when we look for efficiencies. When we look for efficiencies, innovative ideas follow. In our discussion yesterday with the director of TUS, we identified an efficiency sitting at the table right there. And Commissioner Zerfus graciously offered to spearhead that, and that is, fillable forms. Commissioner Zerfus worked with our BCS in developing our consumer complaint forms and making those fillable. That's one of the things that TUS has tried to get for years, is fillable forms. One of the things we are going to be working on is fillable forms for all of our agencies. All of our forms in 2024 should be fillable and not a downloadable PDF. That's an efficiency. That's an efficiency that saves staff time and helps us do a better job internally, as well as servicing the clients we represent, or the customers we're representing. That's the ratepayers of Pennsylvania. So I appreciate your concerns. I do think, though, now is the time to look at this because we have the strategic plan coming. We think that should be tied in together. And again, as we discuss these efficiencies, let's put all of our heads together and figure the best way possible we can serve the Commonwealth. Any further discussion?
Mr. Chairman.
Commissioner Zerfus.
Thanks for the indulgence. I'm going through the joint motion with yourself and Commissioner Yonora. I would like to just point out that as I'm reading it, it says that it's the goal of reducing processing times by at least 15%, but it looks like the executive director does have discretion to make adjustments to the goal percentage based on the inventory results. And the Office of Executive Director does have the discretion or the ability to make a written request for an extension of time based on the inventory results. So, I am going to be a yes on this. I think, we can always do better. Agencies can always do better. But because of this fluid process that's built into the motion, which I appreciate, that's how I can get to the yes. We can do the inventory, going towards this goal. We have the discretion for extra time if we need it. I would agree that I think the time is now. I think we can chew gum and walk at the same time by doing these things, but I do appreciate that flexibility there if we need it. So that's why I'll be a yes. Thank you.
Thank you, Commissioner Zerfus. And I think you do have a good point. The purpose of this is getting that inventory. That's the first important step, is figuring out what all we can do. The reason why we didn't look at statutory deadlines is because we have a deadline in it. That's why we were focusing on applications where there is no deadline in law, and how we can improve those efficiencies.
Maybe I might be being a little too sensitive on this because I come from staff, but I've seen how this place operates. I know the good work that our people do. I know that our complement is down substantially, and I do mean substantially right now. So to put any kind of goal out there while the vendor is doing their work is putting our hands on the scale of the product we're going to get from the vendor. I can't agree with that.
Thank you. Any further discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no.
No.
The ayes have it by a vote of 4-1, noting the dissent of Vice Chair Barrow. Madam Secretary.
Mr. Chairman and Commissioners, that concludes all agenda items to be considered today.
Thank you. Before we adjourn today, I would like to recognize Commissioner Coleman for remarks on Safe Digging Month.
Thank you, Chairman, and in the spirit of organizational efficiency, I will cut my remarks in half this morning, so there you have it. It's April, so those of you who have been with us over the years, you know what that means. It's Safe Digging Month, and kudos to all of our regulated utility folks who celebrate safe digging, not just the month of April, but year-round. You know, this is the time of year where we're putting away, as homeowners, we put away our snow shovels, and we have great plans to get out and start digging and putting in new mailbox posts or trees or whatever it may be. But I just want to remind all of us that we have an obligation, and that obligation is to call 811, just to make sure that we're doing it in a safe manner. And there are stories every day of homeowners that don't make that call, and sometimes they are somewhat inconsequential hits of underground utilities, and sometimes they're catastrophic. So I just want to remind all of us as we are doing those projects and before we put that spade in the ground, make sure we make that call. And make sure you do it at least 3 days in advance. I think that's important to know as well, for our utilities to have the opportunity to respond, get out into the field, and to mark those underground facilities so we're all safe and we don't have a disruption of service. We have a wonderful damage prevention committee that I think does a tremendous job, and they are the unsung heroes. They are the workhorses behind the 811 program, both here at this commission and in Wexford, Pennsylvania, where the data center is operating, that provides all of that data for us to be able to look at and to enforce the one-call law. And I just want to take a moment this morning again to recognize those stakeholders. Those are the industry stakeholders that volunteer their time and their effort and their expertise to come here in this very room and to adjudicate those alleged violations of the law. This isn't an easy job, and this is a significant commitment of time and energy. So I just want to shout out to those who have made the commitment to be part of that damage prevention committee. I also want to shout out to our team internally here within the commission that does the hard work under Allison's leadership. They each and every day go through those alleged violations and try to make sense of what they've got. And there's a lot of data. There is a significant amount of alleged violations that are coming through this program each and every day. And our goal here is to reduce that. And I think just wanted to call out a couple of pieces of data that we've had an opportunity now over the 5 years of providing the enforcement responsibility of one call. And there are some good pieces to the data, but there are also some pieces that I find maybe a bit concerning and to a point of being somewhat troubling. There's still a need for significant education. There are still a majority of folks that do not call one call. They are homeowners, they are contractors, they are utilities, they are across the board. And that is the number one issue, is that the law is still not being followed. And again, those consequences may not seem significant in some respects. In others, they're fatal. And so I think it's important and incumbent upon all of us to make sure that, that we are making that call when we're going to be digging. The data also shows that there is a small group of telecommunication companies that are among the most often involved in our Damage Prevention Committee actions. So these are the telecommunication companies that are aggressively putting in broadband across the state and deploying significant infrastructure improvements, but they are also the ones that are most often in front of the Damage Prevention Committee. And in fact, of the, what we call the top 20 frequent offenders, we look at the data to say, so what is the group of those that are really causing the most problem here? And in that group of 20, 50% of those alleged violations are attributed to our small group of telecommunication companies. So I'm sure all of you are saying, so what are the most common violations? What are the failures that are happening here? And the most often violation is failure for those utilities, those telecommunication companies, to call the one-call system. So if you think about that for a minute, that is a little bit troubling that those that should know better are among those that are not calling and issuing those one-call tickets. The second is marking their own facilities. And so you have a contractor that goes out and believes that they are digging, and all facilities have been marked only to find out that they hit a telecommunication line, and hopefully it's not during the NCAA championship basketball game that you lose your service, right? So I don't mean to make light of it, but in some cases it can be significant that it disrupts business, it disrupts homes, and I think that it's important, again, to remind our telecommunication companies that this is important. And we have the data now, and we're looking to see what the data is telling us. And the goal here is to reduce line hits. And the sooner we reduce line hits and provide education, we all win in this. If you're a facility owner, you're gonna win. That you're gonna have your facilities that are not being hit as frequently as they are today. If you're a property owner, you don't have as much disruption, right? If you're an excavator or contractor, this is better for you. It's better for your employees that you're not out there in some cases, some very unsafe conditions. So my final word this morning is let's be safe, and please call 811 before you dig. Thank you.
Thank you, Commissioner Coleman. I would point out about telecommunication facilities, those tend to be the most shallow as well. So, you know, they tend to get hit a lot because they're closest to the surface. If there's no other business to come before the commission, is there any objection to adjourning? Hearing none, we are adjourned.